is recognized.
I hadn't even asked yet. I appreciate that, Mr. Chairman.
I knew you wanted to talk, brother. I knew. Go right ahead.
Thank you, Mr. Chairman, and I thank my colleague from North Carolina for his legislation. I do disagree with the scope and direction of this. In fact, I'm uncertain about some of the aspects of it. My recollection of Section 1983 litigation is that it's enormously complicated, and as the chairman suggested, having a hearing in advance to sort of figure out what the exact scope of this would be would have been advisable given the nature of this. And I definitely had concerns about the legislation stripping all federal employees of any immunity for conduct within the scope of their employment, as long as it's connected to the First Amendment rights. And I got to say that the examples that my colleagues from North Carolina and Wyoming have offered don't offer me assurance or clear guidance on what the scope of this would be or what it would do. And I do want to raise a question too, and we'll have an amendment about this down the road, but with respect to the explicit exemption of the president and the vice president, I had concerns about that. So just to sort of walk through this a little bit, and I think the ranking member touched on this, it sounds like under this legislation, if an employee mid to low level potentially makes some kind of statement or takes some kind of act that under this provision could be viewed or interpreted as depriving anyone of their rights, privileges, or immunities as secured by the First Amendment, he or she would be personally liable. This doesn't speak to, for example, whether this person is acting in response to a superior, say like someone in an agency or department, have immediate superiors, have a secretary over them too, who might guide guide the statements that they would be making. And certainly the president ultimately would be responsible for those statements that are made as well. So for in the current scenario, federal employees have limited ability to make statements already. For that reason, the government wants to make sure that there's consistency in the statements that are made. And so for testimony, for example, before a congressional hearing has to go through OMB for approval, just to make sure there's coordination. But I would ask my colleague from North Carolina, so in the instance where an individual who is not the secretary of a department or even secretary or even director or administrator of a particular department or agency makes a statement that is viewed as being in conflict with this, would that implicate the secretary of that department and or the president when that statement is made?
Ask a clarification. If they make a statement that does, say that again if you just repeat the question. Makes
a statement that, we're hypothetically here, is in violation or triggers this provision. It creates personal liability.
So you're saying if a lower level employee does something that would deprive an American of their First Amendment rights?
Let's take one of your examples. So I think you had something about Catholic parents, I think it was for school boards.
Yeah.
Okay.
If someone's victimized by that.
Well, walk me through that one. So who would you say is?
It's really, I think, pretty simple, Mr. Ivey, and what it does, this legislation replicates exactly the state of affairs that exists for state officials, state and local officials, under Title 42, Section 1983. Does it exactly. Only thing it changes is if someone acts under color of federal law, as opposed to under color of state law, they would be liable. So yes, police officers who beat someone savagely, even though they're not high-ranking, are subject to liability under Section 1983.
Let's stop there, because that's the example I had in mind. So for example, 1983 is used actually to go after police officers, typically when they've acted outside the scope of their employment and committed acts that are beyond what is viewed as normal policing under the circumstances.
Right.
In fact, it violates the standard in their training.
That's right.
And so therefore they're personally liable. By the way, I haven't seen any of these incidents where their commander said, yeah, continue to beat him to death. So the incidents that we're talking about.
Right. I don't believe, I'm not.
So let's stay with this though. So if mid-level employee makes a statement, and the ones that you all have cited apparently have been, I think you said in some of these hearings, you think were driven by the Attorney General or other, heads of departments. Would the heads of those departments be liable too?
Absolutely.
All right, and how would you prove causation under that scenario?
Give me a set of circumstances, and I'll link it up for you.
This is your hypothetical.
Well, I know. I mean,
Or your set of
you're
facts.
saying, how would I prove causation without giving me a set of facts to target? I can say this: if the director of the FBI if approved a policy under which the FBI embedded itself in a way that the clearly established law, that's what the protection of the qualified immunity doctrine provides that was just criticized a moment ago, instructs FBI agents to embed themselves with social media companies and to coerce them or interact with them so extensively in decisions what to do with discourse of the American people that they're taking down millions of tweets, the director of the FBI would be civilly liable under this language.
I apologize.
That's fine. The time of the gentleman has expired. I'll recognize the gentleman from North Carolina if he wants to go now for continued dialogue. But
I'll wait and see what else develops. Unless if no one else wants to go, I'll certainly ready to.
Yep. Gentleman from Virginia is recognized, Mr. Klein.
Thank you, Mr. Chairman. I want to express my support for the bill.